Hey everyone! Arbitration is a method of resolving disputes outside of court, where the parties involved agree to submit their dispute to one or more arbitrators who render a final and binding decision. It is an alternative dispute resolution mechanism widely used in commercial disputes, particularly for cross-border transactions. Unlike mediation or negotiation, arbitration results in a legally binding award, much like a court judgment. However, it is distinct from litigation because it is private, flexible, and often more efficient. A key aspect of arbitration is that it is contract-based, meaning parties must have an arbitration clause in their contract or agree to arbitration after a dispute arises. Without such an agreement, arbitration cannot be forced upon any party. When businesses enter into cross-border contracts, disputes are inevitable. But resolving these disputes in court can be a nightmare. Jurisdictional issues often arise when parties from different countries are involved, as each party may prefer their home country's courts. Arbitration solves this problem by providing a neutral forum where both parties agree on an arbitration institution or rules. Another major advantage is the enforceability of arbitral awards compared to court judgments. Court judgments are not always easily enforceable internationally, whereas arbitral awards are recognized and enforceable in over 170 countries under the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Additionally, arbitration proceedings are private and confidential, unlike court cases which are generally public records. This confidentiality is crucial for companies involved in sensitive commercial disputes. Arbitration is also typically faster than litigation, which can be prolonged due to court backlogs and procedural delays. Parties in arbitration have greater control over the process, including the choice of arbitrators, procedural rules, and language of the proceedings. This flexibility makes arbitration a more efficient dispute resolution mechanism, especially in complex international disputes. Moreover, arbitration allows parties to appoint arbitrators with specific industry expertise, which can result in more efficient and informed decision-making. The benefits of arbitration go beyond just confidentiality and enforceability. One of the key advantages is the finality of the decision. Unlike court judgments that may be subject to multiple appeals, arbitral awards are generally final and binding, with limited grounds for challenge. Arbitration also gives parties significant autonomy, allowing them to customize the dispute resolution process according to their needs. While arbitration is not always cheaper than litigation in the court, it can be cost-effective in complex disputes due to its streamlined process and reduced procedural delays. It also eliminates concerns about home court advantage, providing a neutral venue for dispute resolution. The SIAC's arbitration rules are widely used globally, particularly in Asia. To commence arbitration in Singapore, the claimant must first ensure that there is a valid arbitration agreement. Arbitration can only proceed if there is a pre-existing arbitration clause in the contract or if both parties agree to arbitrate after the dispute arises. The next step is filing a notice of arbitration with the SIAC, which should include details of the dispute, the relief sought, and the arbitration agreement. The claimant must also pay a filing fee. The respondent then has a specified time, usually 14 days, to file a response to the notice of arbitration, either agreeing or disputing the claims. Once the arbitration is underway, the parties must appoint arbitrators. If they cannot agree on an arbitrator, SIAC will appoint one from its panel of experts. The arbitration proceedings are then conducted according to SIAC rules, which allow for flexibility in hearings, evidence, and submissions. Finally, the arbitral tribunal renders a final and binding award that can be enforced in any country that is a signatory to the New York Convention. While arbitration offers significant advantages, it is not always the best option for every dispute. One potential downside is that arbitration can be costly, especially in complex cases where multiple arbitrators and legal experts are involved. Additionally, the limited grounds for appeal can be a double-edged sword. While it ensures finality, it also means that parties have limited recourse if they disagree with the outcome. That being said, Arbitration remains an excellent choice for resolving cross-border disputes due to its enforceability, neutrality, confidentiality, and efficiency. Singapore's position as a global arbitration hub with SIAC's strong reputation makes it an ideal venue for arbitration. The country's legal framework under the International Arbitration Act provides strong support for arbitral proceedings and enforcement. Ultimately, businesses and individuals should carefully draft arbitration clauses in their contracts to ensure clarity on dispute resolution mechanisms. Having a well-drafted arbitration clause can prevent unnecessary jurisdictional disputes and ensure that any disagreements are resolved efficiently. Arbitration is an essential tool in the modern commercial world, providing businesses with a robust and effective way to resolve disputes while maintaining control over the process. Thanks for joining me in this video. Don't forget to like, share, and subscribe, and I'll see you in the next video.